The virtual hearing into impeach former public protector advocate Busisiwe Mkhwebane's efforts to grab a gratuity, she argues is due to her, kicked off with parties in the same place they left the matter, with no consensus on the way forward, leaving the court to make that determination.
It appears that the parties hold different views as to what the issues ought to be that the court has to determine today. But in essence, what overlaps is in fact the urgency of the application. On the side of the first and second respondents, whether this application ought to have been enrolled on the urgent roll for adjudication today. And this is amongst the other issues that the applicant has also tabled before the court in its letter that the court has to adjudicate. Now, the present application is a matter of great importance to all parties concerned. It raises issues of a complex nature before this court. And then the outcome of these proceedings holds serious consequences for both the parties before the court. On the side of the respondents, if the relief is to be granted, it will have an impact on further matters that might be placed before this court in future of a similar nature. And on the side of the applicant, it will also hold consequences for the applicant if this relief is to be refused. It is against this backdrop that I hold the prima facie view that the dispute between the parties needs to be adjudicated and determined having regard to the totality of the evidence that needs to be placed before this court.
Counsel on behalf of the former public protector submitted that there was no compliance from the respondent, the Office of the Public Protector, specifically with the time period set out in the notice of motion, with the furnishing of the record.
I raised it with my learned friend because I wasn't sure if he was aware. I said, well, you can't give us an answering affidavit, you must give us the record. It was on that occasion that the record was promised to be given on Monday. Instead of being given a record, we were given something called an answering affidavit and a condonation notice.
When the court sought an explanation from the respondent regarding the failure to comply, counsel cited an unreasonable timetable.
The first question is, did the applicant formulate reasonable timeframes? Now,
well, is it your case that it was not reasonable?
Absolutely not. If we examine that at paragraph 11.
Following all submissions, the court concluded that the matter was not ripe for hearing and ordered that the application be removed from this week's urgent roll for enrolment on an alternative date to be determined by the Deputy Judge President upon being requested by the parties. The Office of the Public Protector was ordered to deliver the record and reasons behind the decision not to pay the gratuity before 19 April 2024. The Office of the Public Protector was also ordered to pay the costs on the attorney and client scale. Kani Mapanga, SABC News, Johannesburg.